Get ready for a powerful and intense courtroom moment that instantly grabs your attention. In this gripping hearing, Judge Stephanie Boyd takes full control as Christopher Vincent White faces serious felony charges involving assault against a family or household member. From the very beginning, the tension is undeniable, and every second feels critical as the judge carefully listens, analyzes, and responds with a firm and no-nonsense attitude that sets the tone for everything that follows. As the case unfolds, the situation becomes even more compelling when the defendant enters a plea of no contest and requests deferred adjudication. While the court acknowledges there is enough evidence for a guilty finding, Judge Boyd makes a calculated decision to defer that finding, giving the defendant a chance, but under very strict conditions. What really makes this moment stand out is the judge's strong stance on safety and accountability. She firmly rejects any leniency when it comes to contact with the victim and enforces a strict no-contact order, making it clear that there will be zero tolerance for any violation. The intensity continues as the full weight of the probation terms is revealed. With a 3-year deferred adjudication period, financial penalties, mandatory programs like a BIP course and evaluation, and over 100 hours of community service, the defendant is placed under serious pressure to comply. On top of that, strict lifestyle restrictions, including employment limitations and a complete ban on weapons, highlight just how serious the situation is. This is not just another courtroom clip, this is a moment that shows how quickly things can escalate and how firm judicial decisions can shape someone's future. Stay tuned till the end, because this case delivers powerful lessons, unexpected turns, and a reality check you don't want to miss.
2025 CR 003287, State versus Christopher Vincent White. Can I have parties announce?
Rick Pena for the state of Texas.
Doug Campbell for Mr. White.
And are you Mr. White?
Yes, Your Honor.
Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. White, did you review the true bill of indictment with your attorney? Indictment as presented?
No, Your Honor. We will waive the repeat offender enhancement.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with assault family household member with a previous conviction as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a U.S. citizen, by entering into this plea, you could be deported,
Yes.
not allowed re-entry or naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Lenea, Lenea, Laralde, Larralde. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge. With
State-
one change,
Yes.
believe Ms. Rinaldi now goes by Ms. Bland.
I'm sorry, the last name?
Last name Bland.
B-L-A-N-D?
B-A-L-A-N-D. B-L-A-N-D, yes.
All right. State, is that the plea?
That is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 100 hours community service restitution, the BIPP, cap evaluation, and follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers into evidence State Exhibit 1 with all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most
As the hearing progresses, the intensity noticeably builds when the defendant enters a plea of no contest and seeks deferred adjudication, hoping to avoid an immediate conviction. Judge Stephanie Boyd takes a measured but firm approach, carefully reviewing the facts before acknowledging that there is more than enough evidence to support a guilty finding. However, instead of delivering an instant conviction, she chooses to defer that finding, offering the defendant a second chance, but under extremely strict and closely monitored conditions. What truly elevates this moment is the judge's unwavering stance on safety and accountability. She makes it absolutely clear that there will be zero tolerance for any form of contact with the victim, firmly rejecting any softer conditions and enforcing a strict no-contact order. The atmosphere in the courtroom shifts as her tone becomes more authoritative, signaling that this is not a situation where boundaries can be tested. Every word she delivers reinforces the seriousness of the case, making it clear that even the smallest violation could have major consequences. At this point, the pressure on the defendant becomes undeniable, turning the hearing into a high-stakes moment where one wrong move could change everything.
importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. So, with regards to this plea bargain, I don't see why I should follow the no harmful or injurious contact. Why shouldn't it just be no contact?
I can address that.
Yes.
Mr. White and Ms. Bland, who's sitting here in the front row, have had a conversation while Mr. White was in prison for the previous family violence charge.
And the previous family violence charge, was that against her?
No.
I could, no.
Okay.
But I think that change of heart has led them to understand that this is not the path that they both want to go down. They are going to raise a couple of children together, and if there is a no contact order, that's going to be an impossibility.
What, are these his biological children?
They are not. They're children that she has adopted. Her biological.
Wait, let's slow a bit. So she's adopted some children. I'm reading this police report that she had been living in a hotel from hotel with these adopted children.
Don't believe they were there.
They were not adopted at that point.
Well, that's true.
So she didn't have any children with her at that point.
She may have, Judge. I think the difference, though, is that having served his time, Mr. White and Ms. Bland are asking the court to allow them to have no harmful or injurious contact. He is on probation still for the other case.
Parole.
Parole, excuse me.
Yeah, I don't think this is a good. I'm not going to follow the no harmful or injurious contact.
Can I talk to my client briefly? Judge, in talking with my client and with this plan, they are okay with no contact.
All right. Because here's the thing, you have to internalize what you did. You have someone who's living in hotel from hotel.
I was living
They're
with-
telling you, no, according to the police report, she's telling you, you can't stay with me. And I'm making an assumption that she didn't want you to stay with her because you were not pulling your weight, because she's living in a hotel. And then you come over anyway with your clothes, and then you hit her in the face with a Nike sandal. That's what the police report says. And she had visible redness. So it appears to the court you haven't learned anything from being in prison beforehand or being on probation beforehand with the
Judge,
previous assault.
this was before he went.
This was previously before I've been incarcerated. I've been incarcerated for a year and a half since then.
I don't think your relationship with her would be a good one. And I don't think you would be successful on probation with that relationship.
That
And
is-
I don't think adopted children need to be around that. So
And
any objections? I've heard your argument. What I can tell you, your plea bargain agreement is for no harmful or injurious contact with Linnea. I am actually going to do a no contact order with her. So that is a violation of your plea bargain agreement. So do you still wish to go forward with this plea?
how long would it take to get a trial?
How long, what?
How long would it take to get a trial set?
Oh, we can do it right away.
Okay. Ready.
So,
Right now?
Probably gonna be next week.
Yes, sir. Just go first.
so what do you want to do?
Just go with the no contact. It's fine.
All right, so there's a $1,500 fine that will be probated. There's an affirmative finding of family violence. There's to be no contact.
Judge, with
Yes.
respect to the TAP evaluation, given the fact that he's been locked up for a year and a half, can you do that without?
Let me get to that. Just give me a moment. So there's to be no contact with Linnea, Laraldi, Bland. Proof of employment within 45 days. No employment as a home health care provider or with minors. No residing with minors. The BIPP course. 100 hours of community service restitution. TAP evaluation. Out of custody, follow recommendations. If you miss that TAP evaluation appointment, that's going to be a violation of your probation, you understand?
Yes, Your Honor.
Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person. Regular random UAs.
One other thing,
Yes.
with respect to the requirement for employment, my client does have a disability. That's-
All right. So what's your disability?
I'm MHMR. I have bipolar, PTSD. I have
All right.
ADHD. When I have a stipulation on my parole that I have to go through special needs program, so I'll be having to do programs for that.
All right. So it's going to be proof of employment within 45 days or SSI within 45 days. MIC evaluation, out of custody, and referral for Center for Healthcare Services. Probation, is there anything else? Is there anything?
The length of deferred, Your Honor?
Oh, thank you. 3 years.
I'm sorry, Judge.
No, it's my fault. 3 years deferred adjudication.
Judge, our agreement was 2. We just.
No, that's not a part of the agreement.
This was.
Sure. Okay, sir. I'm just.
All right, 3 years deferred adjudication. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your
All
Honor.
right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, sir.
As the hearing finally comes to an end, Judge Stephanie Boyd leaves an indelible mark with her firm and unwavering message: there will be no exceptions, no leniency, and no room for error. Every single condition imposed on Christopher Vincent White, ranging from the strict 3-year term of deferred adjudication, mandatory BIP and TAP programs, over 100 hours of community service, and the $1,500 probated fine, is non-negotiable. On top of that, the uncompromising no-contact order with the victim, restrictions on employment and living arrangements, and a total ban on weapons or ammunition make it clear that his daily life is now under intense scrutiny. The full weight of these requirements hits hard, emphasizing that accountability is absolute. The energy in the courtroom is electric, thick with tension, as the gravity of the consequences settles over everyone present. Judge Boyd's commanding presence ensures that every instruction resonates with seriousness, signaling that any deviation from these orders will be met with immediate repercussions. This isn't just about following rules, it's about navigating a system where even a small misstep could dramatically alter the trajectory of one's life. The defendant is now acutely aware that his future hinges entirely on compliance, discipline, and respect for the law. For viewers, this ending delivers more than procedural closure. It's a powerful and intense reminder of the high stakes inherent in real-life justice. It showcases how the judicial system balances accountability with opportunity, and how second chances are granted only under strict oversight. The tension, the seriousness, and the palpable pressure make this moment unforgettable, leaving audiences gripped as they witness the stark reality of consequences, responsibility, and the unwavering pursuit of justice.